'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop.
Might be coming round for sure, Shaq.
We've looked at the case where the law has already established that a certain category of person owes a duty to another person. That's happened through cases that have come before. So it's case law, right? Common law sense too. What we're going to look at now is the general test. So this is the kind of test that would have been applied by the courts to get to those established categories. There are two things that you need to establish if someone is going to owe a duty of care. First, we need to have reasonable foreseeability that someone in the defendant's position could cause harm to someone in the plaintiff's position if they were careless. The second thing that you need is that the salient features of the case must be consistent with owing a duty. Now, salient features just means kind of the relevant features, right? The relevant features of the case. This case looks like one where you should owe a duty of care. So let's look at this first element, reasonable foreseeability. It's one of the most kind of difficult to define areas of law, and courts often look at it on a case-by-case basis, but there are some principles behind it, so let's have a look. The key to reasonable foreseeability in the first element, that is whether you owe a duty of care, is whether it was reasonably foreseeable that if the defendant was careless, they could cause harm to someone in the plaintiff's position. So it's not whether they might cause harm to the plaintiff, it's someone in the plaintiff's position. So whatever you're doing, you owe a duty of care to the people you can reasonably foresee as likely to be affected by your conduct. That's why we end up with some of these mandated categories, as I said before. You know, when you're driving your car, it's reasonably foreseeable that you could affect passengers, other motorists, pedestrians, cyclists. Okay, so you owe a duty of care to other road users. So the challenge of reasonable foreseeability is that when you take an action, when you're careless or there's an omission due to your carelessness, there can be a long chain of events of harm that come from that action. And so the question becomes, what should you be responsible for? Should you be responsible for every consequence of every action that you have? And so the law is saying no. Look, some things you can't understand would have come out of an act or omission that was careless. Okay, and so it wants to delineate between what is reasonably foreseeable and what isn't reasonably foreseeable. Now the challenge is that we're using this word reasonably foreseeable, because a lot of things are potentially foreseeable, but the question is, are they reasonably foreseeable? So what's an example that might help us understand that? So imagine I'm like lecturing you in the lecture theatre and you're sitting there, and we know that QUT owes you a duty of care under occupier entrant. So we know that that's a mandated category. But let's think about reasonable foreseeability. I think it's reasonably foreseeable that if QUT don't maintain the steps, you might trip. Okay, that's reasonably foreseeable. I hope you can see that maintaining the steps. It's also probably reasonably foreseeable that if you fall and slip, that you might drop and break your computer, right? So there's a harm that came out of their omission in not maintaining the steps. It may also be reasonably foreseeable that if you trip and fall, you could pull someone down with you, right, and injure them. You see, so what we're getting is further away from the direct issue. The second person that fell, well, they didn't really fall because of the unmaintained step. They fell because someone else fell, which was caused by the unmaintained step. Okay, so that may be reasonably foreseeable. But what happens if, you trip on a step, you fall, you pull someone down, that person coming down bangs their head on one of the desks, they get up and they're bleeding a little bit from the mouth, and there's someone in the room, who faints at the sight of blood, right? And then they collapse and faint because they've seen the sight of blood, banging their head, going into concussion and vomiting, and then someone sees that and there has a psychological breakdown. Okay. So is it reasonably foreseeable? Right. Okay. So I've come up with that example. And because I've come up with it, it's foreseeable, right? I have foreseen that that could happen. So if it did actually happen, however unlikely, it's foreseeable, but it's not reasonably foreseeable, right? There's a long chain of events here. I don't think anyone could reasonably expect that to happen. Okay. And so that's the difference. Where do we cut it off? So what can help us think about this particular problem? Let's have a look at this slide. So I think one of the best ways of thinking about it is with this kind of pond analogy, right? What we want to be able to differentiate is in a long chain of events that cause multiple harms, where do we draw the line? Think about this, ripples in a pond, right? They're the events and consequences that ripple away from the act or omission, which is kind of like the stone going into the pond. The closer, right, the harm to the entry point, to the actual act or omission, the more reasonably foreseeable it is. Okay, so that's the way of thinking about it. How directly linked to the act or omission was the harm that was caused. Now, the second thing that's really important to grasp when we're looking at reasonable foreseeability, is how that test is used, how that criteria is used in the different elements of the test in negligence, right? Because it's used differently. So the test is different under requirement 1, requirement 2, and requirement 3. And to be strictly correct, right, to get the nuance, to get the 7, you need to understand that this test is different. Okay. So what's the difference? Difference is, under owing a duty of care, it is reasonably foreseeable that some carelessness, any kind of carelessness, might cause harm to someone in the plaintiff's position. You're not asking, was it reasonably foreseeable that this particular act or omission would cause harm to this plaintiff? It's more general. Could any negligence by someone in the defendant's position cause harm to someone in the plaintiff's position, right? So you're not foreshadowing that the defendant saw their conduct would cause harm. Would a reasonable person have seen some possibility of some kind of harm? Now that's different to when we go to the breach of duty of care, which is requirement number 2. When we get to that one, we're going to talk about the reasonable foreseeability of the actual kind of carelessness. Okay? Could that actual carelessness cause harm? But we use that test in standard 2. Okay? Then in requirement 3, we actually put reasonable foreseeability onto harm. So by requirement 3, we've established that you owe a duty, and we've also established you've breached the duty. Now we have to ask, was it reasonably foreseeable that it might cause this kind of harm? Okay, so we do ask the specific question through the tests for negligence, but we don't actually ask, is it reasonably foreseeable that this carelessness could cause this harm at requirement 1 stage, right? It's broken up through the test, and you need to understand that nuance and how it's applied to get high marks when you apply negligence. So if we've established that it's reasonably foreseeable someone in the defendant's position could cause harm to someone in the plaintiff's position, the second thing we need to understand is whether this is the kind of case where where the defendant should owe a duty of care, right? What are the salient features of the case? In reality, this again is a complex area with multiple criteria. But to get a sense of how the test works, we're going to kind of work on one core idea. Okay, so this idea is the more control the defendant has over the situation, and the more vulnerable the plaintiff is about the situation, the more likely that you're going to owe a duty of care, right? Control and vulnerability are important, right? So if a feature of the case, a salient feature of the case, is the control the defendant has and the vulnerability of the plaintiff to the behaviour, to the act or omission of the defendant, okay? That's important to understand, and we balance that with the need for the individual to take responsibility for their own actions. And we have our case of parent append as authority for control and vulnerability. Okay, so put those two together. What do you need to establish to show that you owe a duty of care if there's no specific category that covers the situation already in common law? You need to show reasonable foreseeability that someone in the defendant's position could cause harm to someone in the plaintiff's position, and you need to show that the salient features of the case are consistent with owing a duty of care, which we're going to look at the control the defendant has and the vulnerability of the plaintiff in balance with the necessity for people to take responsibility for their own actions. So have a think about that. Application is where it counts. The two core cases that you can look at to understand that better are Donahue and Stevenson for reasonable foreseeability, landmark case around that. And we also have the case of parent append, which is about control and vulnerability. In the next video, we're going to look at establishing a duty of care in a different situation, which is when you give advice, which can be particularly important in business. Next video.